Peace, love, light, and overstanding, family. This is Light Warrior, and it's been a minute since I've been on here. So I hope everyone is doing well. And today I'm doing something a little different. Since the organic people to this land are reverting back to the ways, our old ways, the ways of our ancestors, our way of living before the foreign European hybrid colonists showed up here. We're going to do a public notice today, as our way is oral tradition. So this is public notice and publication, and this is an international document. Notice to agent is notice to principal, and notice to principal is notice to agent. And this is addressed to Steve Webb, acting as 911 addressing assistant, St. Clair County Emergency Communications District, 1610 Cogswell Avenue, Suite B as in boy, 20, Pell City, Alabama. And this is coming from the Ma'at Salagi Kanyen'kehà tribe, Old Southwest Territory, Indian Country, internationally neutralized tribal lands, non-domestic, non-resident, non-commercial, without the United States. Affidavit and notice of allodial title ownership. Any party wishing to create dispute with respect to the claims made herein must do so within 5 days, and such disputes must be signed under oath, bond, and full commercial liability. Regarding commercial paper items found on private ancestral estate lands, be it known now, and let the record show, that I, affiant, sui juris, sui juris, being in care of the mailing location at Old Southwest Territory, Indian Country, internationally neutralized tribal lands, an indigenous organic American elder of Turtle Island, commonly referred to as North America, being of legal age after being duly affirmed according to law, hereby depose and state the following. 1. Affiant's maternal grandmother was full-blood Salagi, modernly known as Cherokee, and Affiant's paternal grandmother was full-blood Kanyen'kehà, modernly called Iroquois. 2. Affiant is chief of the Ma'at Salagi Kanyen'kehà tribe, hereinafter the tribe, a titled, natural, freeborn, flesh and blood, autochthonous, indigenous, American woman. Here we're defining American from Webster's 1828 American Dictionary of the English Language, where it's defined as a native of America, originally applied to the aboriginals or copper-colored races found here by the Europeans, but now applied to the descendants of Europeans born in America. So I will repeat number 2. Affiant is chief of the Ma'at Salagi Kanyen'kehà tribe, hereinafter the tribe, a titled, natural, freeborn, flesh and blood, autochthonous, indigenous, organic American woman. Affiant is the tribal spokesperson. The tribe is neither subject to any entity anywhere, nor is any entity subject to the tribe. Affiant is aboriginal and not a nom de guerre, straw man, or any other artificial corporate construct, as written in all capital letters by the unclean hands of others. 4. Affiant is not a person when such term is defined in statutes of the United States Incorporated or statutes of the several states incorporated, when such definition includes artificial entities. With respect to the federal United States Corporation and the corporate state of Alabama, Affiant is non-resident, not a federal or state-created entity, which is only capable of exercising certain rights, privileges, or immunities as specifically granted by de facto federal or state governments. 5. Affiant's status is allodium autochthon. Sui juris, sui juris, impropria persona, meaning my own proper self, and not an accommodation party to the federal debt. Affiant is not a debtor, nor subject to or of the corporate federal government, nor is affiant a subject of or to its subsidiary, the corporate state government of Alabama. Affiant and the tribe voluntarily choose to comply with the man-made laws which serve to bring truth, justice, balance, and harmony to society. But no such laws, nor their enforcers, have any authority over affiant or the tribe. Affiant is not in any jurisdiction and is not of subject status. The tribe and the tribal members are not in any jurisdiction and not of subject status. Affiant and the tribe have and possess the internationally recognized rights to determine our own status of the state, absent of threat, coercion, or acquiescence to a color of law, a color of office, nor to be subjected to an imposed color of authority. 9. Public servants are just that, servants of the people. The oath taken by all public servants and employees is used to assure the public that workers with positions of public trust will follow the constitutional processes of your system. And I will quote the Alabama Constitution, Section 279 here, where it reads, "All members of the legislature and all officers, executive and judicial, before they enter upon the execution of the duties of their respective offices, shall take the following oath or affirmation. I, blank, solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States and the Constitution of the State of Alabama, so long as I continue a citizen thereof, and that I will faithfully and honestly discharge the duties of the office upon which I am about to enter, to the best of my ability, so help me God." Unquote. Waiver of tort and notice to all trespassers. Acceptance of oath constitutes your open and binding offer of contract to form a firm and binding private contract between affiant and the public official or their employees or agents. This implied contract comes into full force by the choices in action on your part to trespass upon my rights, the rights of the tribe, and freedoms you have openly sworn to protect. The Constitution for the United States at Article 1, Section 10 reads, "No state shall pass any law impairing the obligation of contracts," unquote, which has been upheld in the United States Supreme Court. See Hale v. Henkel, 201 U.S.43 at 8/9/1906 was the year. By your offer and affiant's acceptance, we mutually, willingly, and intentionally agree to the terms of this implied contract. Whereas I, affiant, proclaim this declaration that serves to reserve the common law and indigenous rights of the tribe and myself, pursuant to the United Nations Declaration on the Rights of Indigenous Peoples, the year 2007, and the American Declaration on the Rights of Indigenous Peoples, the year 2016, without prejudice. This declaration serves as legal notice to all administrative and Article 1 judicial agencies, principals, and agents that I, affiant, and the tribe do not and will not accept the liability associated with the compelled benefit of any unrevealed contract and or commercial agreement. 10. The above referenced ancestral estate in reversion was being held in trust de facto by the foreign corporate state of Alabama Incorporated and subsidiaries as escheated fee simple property under color of law within purview of the plausible 14th Amendment to the United States Constitution. The 14th Amendment created a second-class citizen, a corporate person, for the District of Columbia. Affiant is not a 14th Amendment citizen, nor is any member of the tribe. Affiant has the birthright and the blood right to the land, and as such, affiant's birthright and blood right overrides any and all state policies that are made to the contrary. The United States Incorporated entities, agents, and assigns, State of Alabama Incorporated, County of St. Clair Incorporated, and Pell City Incorporated, do not have jurisdiction over the original, organic, autochthonous, indigenous peoples to this land. The United States Incorporated, State of Alabama Incorporated, County of St. Clair Incorporated, and Pell City Incorporated are in fact foreign to our land. 12. 2 paper items were placed on private estate property on or about August 15, 2023. Copies attached. 13. The location of said ancestral estate is clearly known to Steve Webb, an agent of your de facto corporation. Hence the 2 paper items placed on private estate property, tribal land. 14. Affiant is the freehold owner and allodium of the aforementioned estate. Adverse claim of title and reversion of ancestral estate was made on July 4, 2022, and is in the public domain. There was no rebuttal, and the estate is registered in a private allodial trust titled Allodial Irrevocable Private Living Trust of Affiant, dated December 8, 2021, by execution of Declaration of Trust dated December 8, 2021, which I am trustee of. 15. Memorandum of Trust, copy attached, is evidence of the existence of the foregoing Declaration of Trust. Any person may rely upon this Memorandum of Trust as evidence of the existence of said Declaration of Trust and is relieved of any obligation to verify that any transaction entered into by a trustee thereunder is consistent with the terms and conditions of said Declaration of Trust. 8866 Cooks Springs Road is the correct tribal designation for the above referenced ancestral estate located in Cooks Springs, an unincorporated area, according to our story, ancestral customs, traditions, and old maps. Be it further known that pursuant to the American Declaration on the Rights of Indigenous Peoples, Articles 13, 24, 25, 28, 30, and 34, but not limited thereto, Article 13.3, Indigenous people have the right to recognition and respect for all their ways of life, cosmovisions, spirituality, uses, customs, norms, traditions, forms of social, economic, and political organization, forms of transmission of knowledge, institutions, practices, beliefs, values, dress, and languages, recognizing their interrelationship as established in this declaration. Article 24. 1. Indigenous peoples have the right to their traditional medicines and to maintain their health practices, including the conservation of their vital medicinal plants, animals, and minerals. Indigenous individuals also have the right to access, without any discrimination, to all social and health services. 2. Indigenous individuals have an equal right to the enjoyment of the highest attainable standard of physical and mental health. States shall take the necessary steps with a view to achieving progressively the full realization of this right. Article 25. 4. States shall give legal recognition and protection to these lands, territories, and resources. Such recognition shall be conducted with due respect to the customs, traditions, and land tenure systems of the indigenous peoples concerned. 5. Indigenous peoples have the right to legal recognition of the various and particular modalities and forms of property, possession, and ownership of their lands, territories, and resources in accordance with the legal system of each state and the relevant international instruments. States shall establish special regimes appropriate for such recognition and for their effective demarcation or titling. Article 28. Protection of cultural heritage and intellectual property. 1. Indigenous peoples have the right to full recognition and respect for the ownership, dominion, possession, control, development, and protection of their tangible and intangible cultural heritage and intellectual property, including its collective nature, transmitted over millennia from generation to generation. 2. The collective intellectual property of indigenous peoples includes inter alia traditional knowledge and traditional cultural expressions, including traditional knowledge associated with genetic resources, ancestral designs and procedures, cultural, artistic, spiritual, technological, and scientific expressions, tangible and intangible cultural heritage, as well as knowledge and developments of their own related to biodiversity and the utility and qualities of seeds, medicinal plants, flora, and fauna. 3. States with the full and effective participation of indigenous peoples shall adopt measures necessary to ensure that national and international agreements and regimes provide recognition and adequate protection for the cultural heritage of indigenous peoples and intellectual property associated with that heritage. In adopting such measures, consultations shall be held to obtain the free, prior, and informed consent of indigenous peoples. Article 30. Right to peace, security, and protection. 1. Indigenous peoples have the right to peace and security. 2. Indigenous peoples have the right to recognition and respect for their institutions, for the maintenance of their organization and control of their communities and peoples. Article 34. In the event of conflicts or disputes with indigenous peoples, states shall provide with the full and effective participation of those peoples just, equitable, and effective mechanisms and procedures for their prompt resolution. For that purpose, due consideration and recognition shall be accorded to the customs, traditions, norms, and legal systems of the indigenous peoples concerned. Pursuant to the United Nations Declaration on the Rights of Indigenous Peoples, Articles 26 and 27, but not limited to, Article 26, indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. 2. Indigenous peoples have the right to own, use, develop, and control the lands, territories, and resources that they possess by reason of traditional ownership or other traditional occupation or use, as well as those which they have otherwise acquired. 3. States shall give legal recognition and protection to these lands, territories, and resources. Such recognition shall be conducted with due respect to the customs, traditions, and land tenure systems of the indigenous peoples concerned. Article 27. States shall establish and implement, in conjunction with indigenous peoples concerned, a fair, independent, impartial, open, and transparent process, giving due recognition to indigenous peoples' laws, traditions, customs, and land tenure systems, to recognize and adjudicate the rights of indigenous peoples pertaining to their lands, territories, and resources, including those which were traditionally owned or otherwise occupied or used. Indigenous peoples shall have the right to participate in this process. America is the autochthonous, indigenous land of the Americans, Moors. See the treaty with the Delaware Indians, Algonquin, Lenni Lenape, Nanticoke Moors, on September 17, 1778. See also United States 100th Congress House Concurrent Resolution 331 on September 26, 1988. See also Delaware Revised Code 2631, the year 1935, sections 9 and 34, which equates Moors as Indians and Indians as Moors. Although we desire to be a friend to all people, we are not under the dictates of any de facto local or foreign entity, nation, or state. We, the organic indigenous peoples of Turtle Island, now operate under our traditional land tenure systems and customs, the way of our ancestors. As our very ancient custom is oral tradition, this oral reading of this public notice is now in the public domain. On August the 22nd, 2023, and this will be on YouTube. https://www.youtube.com/@the-radiant-one, and that's all one word, @the-radiant-one. We wish to deal with this matter in writing. Permission is not given to contact us in any other manner. Should you do so, I must caution you that it could constitute harassment and stalking, and I may take other lawful actions. If any person choose to rebut this entire notice, they must present their nationality for the public record and rebut word for word, line by line, sentence by sentence, paragraph by paragraph in writing, which must be notarized and mailed certified within 5 days upon acceptance. Failure to rebut this notice will automatically constitute default, because silence can only be equated with fraud, where there is a legal or moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. Therefore, your silence upon default constitutes an acknowledgement of every word written within this said public notice as the truth, the whole truth, and nothing but the truth. I, affiant, state that the facts contained herein are true, correct, complete, and not misleading, to the best of my knowledge, pursuant to our story, your story, his story, the great law, Kanyen'kehà, and international law. Put in the public domain this 22nd day of August 2023, affiant sui juris in full life in propria persona, all rights reserved. And that completes the reading of this public notice and publication. It is now in the public domain. So be it, so be it, so be it. It is so, it is so, it is so. And this is Light Warrior. I'm signing off. Peace, love, light, and overstanding. Thank you for watching and listening.